सर्व साधुने वंदन करता, सम्यक दर्शन मुझने मळजो, सम्यक ज्ञान मुझने मळजो, सम्यक चारित्र मुझने मळजो, नवपदनी आराधन करता,
Welcome everyone for the final webinar of this year in the Living Beyond Barriers series. I'm Urvina Shah, a committee member of Enabling Network, and I'll be hosting tonight's webinar on behalf of Shilpa, and she's the OE UK trustee of Health and Welfare and Enabling Network, and she sends her apologies. Now, our speaker for tonight is someone who truly wears more hats than most of us have in our cupboards. He is no stranger to community service. He's an EC trustee of OUK, looking after the religion portfolio, and over the last 35 to 40 years has held many trustee roles across various other organizations. Now, if you've recently been to the British Museum's Ancient India exhibition, he's the one who was one of the community advisors to it. With over a decade of experience, he holds senior positions within the Society of Will Writers and is recognized as one of only 35 fellows in the UK. Now, tonight, he's here to guide us through sometimes daunting world of wills, trusts, and power of attorney, and to help us make choices that are both informed and inclusive. Now, throughout this presentation, please feel free to write in your questions, and I'm sure he will do his utmost to answer them as much as possible within the time frame we have. So without further ado, please join me in welcoming Shandip Shah.
Jai Jinendra, and thank you, Ravinaben, for that very kind and warm welcome. Thank you to Enabling Network for putting on these webinars, these programs for our community. Very, very useful indeed. Now, tonight, just make it clear, today is for all of you, the audience who are listening out there, for you to take in the information, whatever I impart, for you to take this and make decisions accordingly. It's not about me. It's not about my firm, nothing like that. Today is about, or this evening is about you. So there are two parts to my talk today. First is on wills, trusts, and the second part is on lasting powers of attorney, an equally important topic. So without further ado, I'm going to share my screen. And Urvina, everything coming through okay?
Yes, looking good, Shandip. So far, so
Perfect.
good.
Perfect. Okay, so let's start without further ado on wills. So I'm sure all of you who are listening this evening or who will be listening later on YouTube will know what wills are, but I'm going to start from the basic and skip through some of the areas and then come to the important points on the wills. First and foremost, as soon as you're born, there is a guarantee in life that one day we will take leave from this earth. We will pass away. It is so important that actually there are many, it's one of the few areas which people actually prepare for. Prepare in a sense, we know it's a guarantee, yet we're hesitant in some way. And there are many reasons for this. Just to highlight some of the reasons, people don't want to talk about it, quite understandable. It is a horrible subject to think about. Also, for many people, and I've heard this, they say it's not my problem. after I've gone, it really isn't my problem. So really, you know, it's down to the individual. Okay, but there are very good reasons to make sure you have wills in place. Now, in terms of stats, in this country, around 60% or 56% was the latest figure who do not have a will. Not every single person needs a will. So let's not be fooled by that. There are people in this country who have no one, whose estate is very low, have no savings, no estate, etc. So maybe a will is not needed and it's going to go to the people they want anyway. However, majority of us who are probably listening on to this seminar, a will is an essential part of your planning, financial planning, as well as well-being planning. First and foremost, peace of mind that you know what your wishes are in terms of death. There are tax advantages to having a will, especially husband and wife, or protection advantages. When you do the will planning, you're aware at that point of what your financial circumstances are, and you are then able to better take lifetime planning decisions as well in terms of, you know, mitigating, reducing inheritance tax, etc. One of the big things is to avoid stress on your loved ones and to avoid guesstimating from them what you would have wanted on your death. So the one document you can do is a will. In simple terms, a will is your wishes of what you want to happen to your estate after you pass away. In Gujarati, તમારી ઈચ્છા શું છે કે તમે વહી જાઓ પછી તમારી જે મૂડી છે, તમારું ઓનરશિપ છે, એ ક્યાં જશે, કોને જશે. So I've given you the definition. We've talked about the reasons of not making a will and why people don't make a will. However, there are certain other things. Cut out the uncertainty, avoid a long probate process. Probate is the process after death, which we're not going to talk about today, but the probate process after death. Your assets going into the wrong hands. Without a will, there is a chance that your assets could go into the wrong hands. One of the biggest areas I'm facing at the moment and within the industry is there's a huge area of will contentions right now. Feuds, infighting, etc., because there's no clarity on the deceased on how they want the assets to go. So avoid intestacy. Intestacy, the bottom right-hand corner, is basically you passing away intestate. The word intestate means you've passed away without a will. If that happens, you have no choice on how your estate is going to devolve. The government has rules of intestacy, and basically that has to be followed. When should you be making a will? Key times, any age above the age of 18. 18 is the earliest when you become an adult, but the key times are when you first purchase a property, either a marriage, divorce, or separation. Again, you need a new will. And also, the most important, which I get, is when a couple have their first child. Now, there are good reasons for that, and I'll explain that in a moment. There are myths surrounding all of this. One of the myths is a spouse gets everything if you die without a will. If you're married, you have children, and your estate size is over £270,000, this myth is incorrect. The spouse does not get everything, and I'll come on to the rule of intestacy in a short while. So everything depends on the size of the estate. If you can avoid it, avoid intestacy at all costs. Very quick look at the rule of intestacy, i.e., passing away without a will. If you're married or in a civil partnership, if you have children and your estate is over £270,000, now the rule is just changed to 270, your surviving spouse will get the first 270. The balance will be cut in half. Half will go to the children, half will go into life interest for the surviving spouse. If you have no children, yes, the surviving spouse then will get everything. If you have no spouse, or the spouse has passed away, your parents will get, then your siblings, then your grandparents, etc. So it goes down the line. And guess what? If you have no one, there is always one party which is there with open arms to take your estate, the crown, the government. So what goes into a will? And I'll look at in detail of some of these aspects. So obviously the executors, trustees, your funeral wishes if you want to put them in, guardianship of your children, and any gifts, donations, etc. you wish to make after your death. This is a really important area because I'm addressing an audience of, from Enabling Network, possibly you may have disabled, elderly parents, you may have disabled children. Role of executors and trustees, please do not underestimate. Now, generally speaking, in our families, if we have children, we will nominate our children, absolutely fine. If there's a trust in the will and the ultimate beneficiaries are going to be children, where there is a trust in the will, it's very, very important to have an independent trustee also there. So someone not part of the family, but who may well be needed to manage any kind of conflict, etc., between the children. And believe it or not, it does happen, and it happens quite regularly. So where there is a trust in the will, it's always important to have an independent trustee. Guardianship. Parents who have young children under the age of 18. If both the parents pass away before the child turns 18, the law in this country is very clear. That child will go into foster care first until someone, member of the family, puts in a court application to take guardianship or custody of the child or children. Now, what's the danger there? They may not be the guardian you would have wanted. However, because you didn't plan, you don't have a choice. You've obviously passed away. So until that court order is passed, the child will remain in foster care. Typical period, no one knows, but 4 or 5 weeks, quite simply. Funeral wishes, it's the only part of the will which is not legally binding. Important in terms of funeral wishes, do share those with your loved ones, with your executors, with your family. If you have particular wishes in terms of funerals, do share them. The will does not generally get opened for many weeks after or a few weeks after your death, at which point the funeral has already taken place. So if you do have specific wishes, always make sure your family is aware of that. Gifts you can make, usual, and more now we're getting digital assets, etc. But personal chattels, you may want to give jewelry, you may want to give personal possessions to certain people, gift of pets, money gifts, gifts of property, all of that. Charitable gifting is now becoming much, much bigger. Legacy giving has grown to its highest levels, and that comes from wills, because there are tax advantages as well in terms of charitable gifting. After all of that is done, after any inheritance tax or death duties or costs of administration are taken away, then you get what's known as residue. And this is where I'm going to spend a bit of time in terms of explaining the different types of wills. So first, you have a simple will. So there's simple versus trust-based wills. Simple will, in typical way, would be, say, as an example, husband, wife, 2 children. Simple will say, if one of the husband or wife passes away, everything goes to the surviving spouse. On the death of the second person, everything goes down to the children in equal share. If they're not there, down to their children, or basically down to their bloodline. Simple wills, absolutely nothing wrong with them. What I'm talking about is there is no right or wrong answer. Everything depends on circumstances, value of the estate. But simple wills, there's absolutely nothing wrong with them. They still give you tax advantage on first death, i.e. you get spousal exemption, and second death, it will go down in line with your wishes. No issues, okay? Then we have trust-based wills or advanced wills, as we call them in the industry. The most common one is a life interest trust of the main residence, or sometimes known as protective property trust. Now, 90% of our clients, 90% of the people in this country, the biggest asset they will have is their main house. And there's always a worry of what happens if someone, part of the spouse, passes away young, you have children, and the spouse gets remarried. Or for older couples, what happens if one passes away, the second one goes into care. With a simple, straightforward will, because everything goes into one person's name, there is a danger that your property is at risk. Now, I'm going to show you a very short video. Hopefully this will come on.
Many couples make basic wills, leaving everything to each other and then to their children. The problem here is that what the children receive, if anything, depends on what happens in the survivor's lifetime. And this is why existing wills are revoked by remarriage. The new spouse could inherit everything. Care fees can rapidly use up the estate. Bankruptcy and debts can swallow up inheritance. There is a risk of family conflict, especially in step families. A parent or step-parent can make a new will, so the original beneficiaries will no longer inherit. So what's the alternative? Alex and Sam want to protect their children's inheritance and have peace of mind. Their home is their most valuable asset. They make wills, including a protective property trust, and leave the rest to each other. They each have a share of the property to give to their children, at the same time as giving rights to the survivor of them. If Alex were to die first, their chosen trustees make sure the property is protected and the terms of the trust are kept. This means Alex's share of the home is protected for the children, even if Sam remarries, makes a new will, or owes money to others. Sam continues to live at home and has rights set out in the trust. The trust ends on Sam's death, and the children inherit Alex's share of the property. If Sam hasn't remarried or made a new will and still owns the property, the children can still benefit from this under the terms of Sam's will. If you want to...
Okay, so a really important trust. It is not a tax tool. It is purely as a protection measure for your house in case of something else happening after first spouse passes away. What other type of trusts are there? So we have another trust called the flexible life interest. Again, similar way to the way the property protection trust works, but this is for someone with a large estate. By large, I mean anything generally 3-4 million plus. Again, same concept. When one passes away, there's a life tenant, which would be the surviving spouse. But the difference with this is basically a generational planning tool where when both the spouses pass away, whatever the estate remains after the payment of tax goes into a discretionary trust for the children, the grandchildren, great-grandchildren. Now, typically when we have these kind of large estates, you normally find the children are also relatively financially secure. Either they have good jobs or they're part of the business, etc. So having such a trust makes more sense for generational planning tool where the children may not need to dip into that trust, but it's used for the next generation or generation after. So discretionary trusts are part of that. Then a really important one, potentially for the audience here tonight, is disabled trust. Disabled trust is really a protective trust. So if there is a member, i.e. a children, or a beneficiary who is registered disabled, has learning difficulties, will not be able to manage any kind of money, but do have benefits, government benefits, etc. Having a disabled or vulnerable person's trust and putting, say, if you have 2 children, you're putting half into that trust for the disabled child, will not affect their assessed government benefits, anything like that. So that trust is managed by the trustees you've nominated for things like, say, needs of the child, if they need holidays, to pay for any additional activities, all of that. And the benefits the child receives from the government will not be touched. And of course, on the child's death or the disabled person's death, the estate is that part is valued and it goes down to the other beneficiaries. Normally, it's important with a protective trust, a further discretionary beneficiary is also named, which would be if you have a couple of children, then it will be the other child. These are not that well known, but they are extremely important trusts. If you put it in a wrong kind of trust and the person is disabled, you do have to think how, in terms of they're missing out in terms of tax benefits. Now, vulnerable persons trust, when registered, it doesn't have the usual tax rules of a discretionary trust. So entry charges or the 10-yearly charges are not there. Yes, when the disabled person passes away and there's a remainder in the trust, yes, that will be subject to the estate being valued at that point for the disabled child or the disabled person. And then if there is tax due, but otherwise it will go to the whoever the remainder man or the final beneficiary is. So really important, if you have such a person within the family, then do consider these kind of trusts. Very, very important trusts. Now, we talked about another trust. There's discretionary trust. There is also a lot of people now setting up these kind of trusts while they're alive. First as a tax tool, also as a protective tool. But in a will, if you do on second death do a discretionary trust, there are reasons for that, and it's not always tax. Many, many parents now are concerned and worried about children, beneficiaries who have other issues like them being spendthrifts, money problems, divorces. I have a lot of cases the children are addicts to alcohol, addicts to drugs, gambling issues, all of that kind of stuff. Very, very important that if you do have someone like that within the family, of course you want to provide for them after you die, but there are ways to provide for them. Rather than a straight gifting in the will, you would probably, it is advisable to consider looking at discretionary trust, which is then managed by a third party, a trustee. You would then do a letter of wishes to say, look, this is how I want the money to be used for this particular beneficiary. So really important, when you're doing these kind of things, make sure whoever professional you're using, you give them the full information rather than just going for a simple option. Always important to consider all the facts in the round about your personal circumstances and your beneficiary's personal circumstances.
Sorry, Shandip, I wonder if I
Yeah,
can interrupt
of
at this
course.
point, because I have a question related to that piece that you talked about earlier.
Mm.
The question is, if you already have a will and do not have a protective trust or have a different type of trust, can you change? And with that, the question also is, which one would be better to use, a discretionary trust or a disabled trust?
So the second answer is very easy. I don't know because I don't know the circumstances.
Fair.
So it would all depend on circumstances. If the person is registered disabled,
Okay.
yes, of course. It's always best to use a disabled person's trust.
Okay.
If they're not registered disabled, then we would need to consider discretionary trust, life interest trust, etc. Now, the answer to your first question, wills can be changed anytime. Will is not there. You should, if there's ever a change of circumstances, will should be changed. Okay. You should never go into drafting a will thinking that, yes, this will now be fine for the rest of my life. No, because people's circumstances do change later down the line. So wills can be changed absolutely anytime.
I think their question is around changing the trust, the protective trust or a different type. Can they do that?
Yes, they can.
Okay,
Because
great.
the trust has not come into being because the person hasn't passed away yet.
Okay. Hope that's answered that question. Thank you.
So I'll continue. So another important area I wanted to share with the audience today is, and this is something which I've put in the slide only about 2 years ago. This is an area which is now quite prominent, not just generally within the UK, but also family dynamics have changed, family relationships have changed. And I always say this when I'm giving a talk, money can be a cause of a lot of evil. Okay. When someone dies, people come out of the woodwork. But before that, when you're making a will, and say you have a family, 2 children, but you only want to give 1 child, and you may have absolutely good reasons to do that, excluding someone in a will. Whenever we come across a client like that, alarm bells sound straight away. We have 2 laws in this country. First, under the Wills Act, you have testamentary freedom, which says you can give whatever you want to give, whoever you want to give it to, absolutely fine. You have that testamentary freedom to do that. A law came in 1975, which is up on the screen, Inheritance Provisions for the Family Independence Act. In simple terms, if you've looked after a beneficiary while you've been alive, and they are a direct descendant of you, the law says you have a duty to look after them after you've passed away. Okay? What that means is you have a duty to provide for them via your will, via your estate, after you die. Now, we get many situations where families lost touch with a child. For whatever reason, family dynamics have changed. And the parent now wants to exclude that child from the will completely, or give a very different percentage. Rather than 50-50, it would be a very marked difference. Whenever we have that, absolutely make sure you have something in writing, detailing a timeline, detailing an explanation of why you want that child to be excluded from your will. There's nothing to stop you excluding a child. All I'm saying is, after you die, there's a very high chance this is going to end up in the courts, as the will is going to be contested. Like I said, money is a cause of a lot of evil, and people do come out of the woodwork. I have had people who've passed away where they haven't seen a child for 30 years. On their death, they're knocking on the doors. They've put a caveat on the probate. Probate cannot move forward because they're contesting this will. The judge has nothing to go by. So if your will is called up in the law of contention, which it will be, the judge needs information as to why this child was missed out. The onus, of course, is on the child to prove. He has to take the case forward, but also the person who's made the will, there should be information there to say, okay, this is the reasons why we missed out the child, legitimate reasons. Many are, they've already provided for them while they're alive. After death, they want to provide for another child. So it's equalization. So put it all in writing. Make sure you have records of all of this, and make sure whoever's writing your will has a record of this. Right. So the final sort of length on the wills, what makes a valid will? Must be signed by the testator. Testator or testatrix is a female testator, person who's writing a will. They must sign in front of 2 witnesses, exactly at the same time, but in front of 2 witnesses who are independent. Independent means away from the will. They're not related to any party who's a beneficiary of the will. Most important, the person who's making the will must be of sound mind, have adequate mental capacity at the time of making the will. And the will must never be altered in any way. Don't write over the will, don't make marks over the will, because it could be construed to be damaged or altered on death. General tips: store them very safely. Take this document extremely seriously, because this is probably the most important document you're going to make. Store it safely, either store it in a vault, or many of the providers do provide free storage or storage services. So use that and make sure your executors are aware of where that will is kept, because it's the executors who will be liable to actually make sure this will is disclosed. If you have assets overseas, especially property, make sure you've checked the succession law of that country, but also it's always advisable professionally to have a separate will in that country. Now, the biggest culprit is India. In a sense, from what I see, because a lot of my clients are Indian, if you have property in India, make sure you make a will in India to deal with the Indian assets only. And the UK one can deal with worldwide assets, excluding India. It makes the probate process a lot quicker. It makes releasing your assets in a different country a lot quicker. So do make sure if you have assets in different parts of the world, there are separate wills done in those different countries. So give this document the importance it deserves. Leave a lasting legacy. Absolutely important to say that. It's obvious, but leave a lasting legacy. Make sure your family does not fall apart because of your irresponsible mistakes in writing the will and the way you've done it. I see many of these, and please don't fall into these kind of traps.
Shandip, I have something
Yeah.
that might be related to this, or it might come up later, but
Sure.
let me bring it forward. They've said, should I put everything that I have in trust for my children or write a will? My concern would be inheritance tax. I don't know if that's something you answer now or later.
No. We'll go for that now. So basically, you're looking at what's known as asset protection trusts. I can't give you a full answer in a sense. I don't know the values, etc. But I'm assuming the person who's written this is above the inheritance tax threshold and are aware that there is an inheritance tax issue. Putting everything in a trust is down to you. You can do whatever you want with your assets. So if it's typically, if it's a husband and wife, putting up to 650,000 in the trust, survive 7 years, all good. If you put anything in excess of 650, you'll have to pay a 20% upfront inheritance tax. And if you pass away within the 7 years, the other 20% is payable anyway. But there are other bigger dangers. So if you get rid of all your assets and put them in the trust, firstly, we wouldn't do them. We wouldn't advise it. But if you fall ill, you go into care, first thing the local council will do is actually check what your financial position was, check the land registry records, all of that. The government have given them a clear power. If they think you've done this as a deliberate deprivation of assets, then that entire trust is likely to be overturned. Deliberate deprivation is basically you taking action to avoid care fees, healthcare fees, if you were to go into care. Okay, a lot of people do it for that reason. For tax reasons, absolutely you can. You've got to be aware of the tax laws. You've got to be getting professional advice. One thing I would possibly refrain from doing, but again, I don't know the value of your estates, etc., is your main residence, because obviously the main residence carries a bit more weight in terms of inheritance tax. You get the residential nil rate band. But if your total estate is sizable, it's an option. I wouldn't do everything. You need still some money. But if you put in, say, your main residence in there, you will have to pay the trust rental to live in your main house, because now you're no longer the owner and yet you want the benefit. So again, the gift with reservation rules could well kick in or will kick in. So just make sure you're paying the trust, the market rental on that. The trust will need to then disclose that. So there's a lot of advice that's required. There are specialists to do this kind of work, trust specialists to do this kind of work. I'm not saying it's not possible. It is, of course, it's all of this is possible, but you've got to tread with care.
Yeah, does sound very complex, and of course I understand it seems to be, it obviously has to be very individual
Yes.
in what the circumstances are. So for this person as well, I hope that has answered your question, in that it sounds like you need to get advice in terms of what your circumstances are. But thank you for that, Shandip. Yeah,
No
we can
problem.
move on.
All right. So if there's no more questions on the will side, and we can take them later, I'm going to move on to lasting powers of attorney, the second part of this talk. I'm just going to share the screen. Okay. Rubina, can you see the screen okay?
Yes, it's all good.
Perfect. Okay. So lasting powers of attorney have been in existence since 2007, 2008. Probably the most important documents now, if not as important as wills, more important than wills. I see a lot on the other side. If you fall ill, lose capacity, have an accident, etc., really, really important, and I'll explain why. So first, what is a lasting power of attorney? Lasting power of attorney is where you give a power. So you're the donor, you're giving power to a person named the attorney, who is a trusted person or people who you know, to be able to take decisions in your best interest on financial and health matters and health and wealth. So financial and property and health and welfare. There are two types of lasting powers of attorney. Benefits, obviously you're appointing trusted people, avoid court of protection. And again, I'm going to come on to this. These documents do last a lifetime and they're legally binding, stamped in the court. They're governed in the top level by the Mental Capacity Act 2005. The governing court is the Court of Protection, and the governing office is the Office of the Public Guardian based in Birmingham. Office of the Public Guardian is where everything goes. Now, just to give you a bit of a stat, when these were launched 2007, 2008, in that year, there were about 2,500 to 2,800 lasting powers of attorney registered. Current figures now, estimate from the Office of the Public Guardian, when I met the director a year ago, they were doing around 4,500 every single day now. In COVID, that was up a little bit, but around 4,500 to 5,000 are registered every single day. So you can see the huge amount of growth that's actually happening with lasting powers of attorney. There are two types. First, there is the financial and property lasting power of attorney. This deals with money matters, properties, bank accounts, etc. You're giving the power to the attorney to be able to make decisions in your best interest on financial matters. It doesn't give them the right to invest, change your investments, risk your money, make a new will for you. No, if you've lost capacity, none of that is being done. But what it's doing is it's giving them, because you've lost capacity and you're no longer able to manage your finances, it's giving the people you've nominated the power to be able to deal with your day-to-day banking, your costs, all of that in a legal and proper manner. With the financial and property lasting power of attorney, there are two ways of activation. You can choose either that power of attorney only comes into effect if you've lost capacity, which means a doctor has to certify the loss of mental capacity. Without that, power of attorney cannot be used. Or the second option, which is the one 99% of my clients choose, is you can give the power whenever you want to after registration. So having that power of attorney and keeping it flexible, i.e. the latter option, say if you have a car accident or elderly medical symptoms, things like severe arthritis, cannot walk, mobility issues, your mental capacity may be completely fine, but you can't get out of the house, you can't go to the bank, or there are not many banks around now anyway, but you can't do various things. That power of attorney will let the attorneys be able to deal with your financial matters. If you have properties, they'll be able to deal with all of that, rental agreements, collecting the rents, all of that. Really, really important document. So, but the two ways of activation on that. Health and welfare power of attorney is, as the name says, to deal with your health and welfare. However, the key difference here, as opposed to the financial power of attorney, is this power of attorney can only be used if you're unable to make your own decisions due to loss of mental capacity. The loss of mental capacity means, say, if you have an illness like Alzheimer's, Parkinson's, where doctor has certified you've lost capacity. Very sudden illnesses are strokes, heart attacks, where you could be losing capacity on a temporary basis, or you have a coma, something like that. Health and welfare, lasting power of attorney is there for the attorney to be able to make decisions in your best interest in terms of healthcare, your care at home, your care in a care home, care in a hospital, all of that, right up until end of life decisions or life-sustaining treatment. So there are three parties to all power of attorneys, whether they're financial or health. First is the donor. Donor is the person who is making the power of attorney. When at the time of making the power of attorney, you must have full mental capacity, the ability to make your own decisions. You must be your cognitive, your comprehension of what power of attorney is. It's got to be there, but you've got to have adequate mental capacity where you have nominated your attorneys without any kind of undue influence or coercion or anything like that. You must be over the age of 18. And on the financial one, over the age of 18. One thing is very clear. After the age of 18, you're never too young to have these lasting powers of attorney. I'm getting a lot more parents taking out these when their children are going to university. Life is now living in a fast lane, especially for these youngsters, and you don't know what tomorrow holds. They could have an accident when they're enjoying themselves, doing a sporting activity or whatever. As a parent, as an attorney of someone who is just 18, 19 years old, you have no rights in terms of making decisions for them if they've lost capacity because you don't have that legal document. Very important, it's never too early to start. Second party is the attorney. Attorney generally tends to be your spouse, tends to be your children. But most important, the criteria is you've got to have trust in your attorney to be able to make decisions in your best interest at all times. Now, it tends to be friends, it tends to be immediate family. Occasionally, if you have absolutely no one, there are professional firms who can act as an attorney. I've never done one of those. We're not allowed to act as attorneys, but there are firms who will do that. It's a long process, but when they are needed to step in, it could be a very expensive process. Of course, you must appoint someone who has adequate mental capacity themselves, who will always be able to make and will make decisions in your best interest. On the financial power of attorney, they must not be a bankrupt. So that's a key thing. Obvious reasons they're handling your money, okay, when the time comes.
Shandip, I wonder if I can bring in one more question.
Yeah.
This is regarding LP, lasting power of attorney. So if you have a child who has got learning difficulties, and whilst they have mental capacity, they may not have the cognitive abilities to understand decisions that are made in terms of their health or wealth. So where does the attorney stand in terms of, in these sort of areas? Because it seems to me that's quite gray, because it seems from what you're saying, lasting power of attorney only kicks in when that person loses that mental capacity.
So the financial power of attorney, if structured in the right way, can be used whenever the person wants to give them the power, or as it's flexible. Say if it's a child who has mental capacity but unable to do their own things, that attorney is able to then handle everything. On the health one, the reason the government and the courts have that criteria that they must have lost their capacity is because up to that point, if the doctors, the medical profession are asking them questions, they're able to answer them in their own way. So that's mental capacity. Now, what you've talked about is the cognitive impairment, which is related, but then what you're saying is they may not be able to reply back or give proper answers to a medical profession.
Yes.
However, at a young age, that parent would have been nominated as the next of kin, as the decision maker. And normally NHS is actually very good
Yeah.
because they've got a history of having that record of the parents who have that the power. So the power is there is only if they've lost capacity will that come into play. So
Right.
things like, say, if that child goes into a coma, if they've lost, that means they've lost capacity.
Yeah.
Okay. Or in a very, very serious accident, but they must have lost capacity, then the parents, etc., can demand and basically dictate in terms of their health and put their foot forward. I've had cases. If we've got time, I will actually just give you one case which I came across 2 years ago. This was someone who was perfectly fine. They only came to me 2 years ago, but their power of attorney was done about 6 years ago. They had a heart issue, and they'd done a power of attorney. And this actually relates to something I'm going to talk about in a moment, but they put an instruction in the power of attorney. You get preferences and instruction. They put an instruction in the power of attorney to say, if I'm out for more than 20 seconds, I must not be resuscitated, DNR. First, you can't put DNR in a power of attorney generally, but they put that as an instruction. Now, roll forward 4 or 5 years, they had heart issues. They were going in there for major open heart surgery. The surgeon saw the power of attorney. He saw this instruction, and the next day he cancelled the operation.
Wow.
Why did he cancel the operation? What's the role of the surgeon? Surgeon's role is to save that person's life at whatever cost. The attorney, so he basically took a legal standpoint to say, look, if I save the life, the family, who was the attorneys, the children, could have sued him for keeping their father alive against his wishes in the power of attorney. So he cancelled the operation. They came to me. We redone another power of attorney, did not put that in the instructions, did not put that in the preferences. Yes, he had a wish that, look, if I'm on a machine, if I'm in a coma, on a vegetative state, I do not wish to live the rest of my life or live on a machine. Fine, but it's in preferences. Now, come on to the difference between preferences and instructions. Drafting is absolutely essential. Putting instructions, clear instructions are really important, but this is the kind of mistakes you can make. But in answer to your question, the person has mental capacity. The power of attorney cannot be used, but generally, if someone has since birth or since early age have issues, then normally the parents, NHS is very good, and parents will views will always be taken into account.
Oh, that's quite reassuring to know. I have another question regarding attorneys. What if an attorney is chosen who then loses their mental capacity? Can you then immediately alter your own LPA to change to a different attorney?
Right. So a very good question. So first, we normally would say have more than one attorney. Okay. But if it's only your one attorney and they've lost mental capacity, you have to start the entire process again. You cannot alter a legal deed which has been stamped by the court. But if you had multiple attorneys, person who's lost their capacity, and if it's on a joint and several, person who's lost capacity would basically simply not be able to act, and they would write to the court to say this person has lost capacity, but the others are able to continue, and you do not need to redraft another lasting power of attorney. If you only had that one attorney, which is dangerous anyway, then you would need to start the entire process again, revoke the power of attorney, but at the same time do another brand new one.
Okay. Great. I have one more question. I'm a little bit unsure about this, but I'll ask it. What happens if someone has a cognitive impairment? Can they still make a power of attorney? Don't know.
So cognitive impairment, I'm assuming you're talking about unable to sign, maybe maybe unable to understand. So what we would, but if they've got mental capacity, so what in those situations we would do is get a professional mental capacity assessor.
Right.
They have a different way of assessing, and if they feel they've got enough understanding as to who they want to appoint as attorney, what their wishes may well be, if they want to put any wishes. Key thing is who they want to appoint as attorney, and they're able to understand the document and its powers, then yes, you can. If the mental capacity assessor absolutely says nope, they've lost capacity, then we go down to another route, which I'll explain in a moment.
Okay, let's carry on as time is of the essence.
Yeah. So attorneys, so make sure, obviously, that the choice of attorneys is really absolutely vital. If you're only going to, so from your last example, if you're only going to appoint one attorney, then we always recommend having a replacement. So put a reserve. There's a section there where you can put reserves. So if something's happened to the main attorney, the reserves will kick in. We don't need to make a new power of attorney. The reserves are upgraded or replacements are upgraded to become main attorneys. Typically happens in families where children are quite young as in adults, but the parents are quite young as well. So they'll make a power of attorney where each of them are sole attorneys to each other, the spouses, and the children are the replacements. Really, really important to have that. Decision making. Now, decision making in power of attorneys can be sole decision if you've only got one attorney, joint if you've got multiple, or joint and several. Now, when it comes to decision making, I never ever do joint. Joint decision making on a power of attorney comes with lots of dangers. If one attorney out of the 2 or 3 who are appointed either passes away or loses capacity, your entire power of attorney is finished. Joint also means every decision, small or large, has to be done by everyone together. So if the donor wants to take £100 out of the bank, all 3 of them need to go. It really isn't practical, especially if the attorneys live far away, etc. So I always recommend to clients keep it joint and several. Joint and several means any one of the 2 or 3 or 4 you nominate can take decisions. So it's little things one can deal with. Large decisions like selling the house or basically switching off the life support machine generally will be taken by joint decision making. Now, in an era where communication and technology is there, most family groups tend to have WhatsApp groups, so they will always inform each other that, look, today I've done this in the bank or I've done this in the bank. So everyone is aware, but not everyone has to go down to the bank. So joint and several is the way to go. So I always say that to clients. Joint comes with its own many, many risks as well. Then the final party to the lasting power of attorney is a certificate provider. Typically someone like us who is a professional, or someone, if you're doing these power of attorneys on your own online, which you can do, a certificate provider is someone who has known you over 2 years, who is not a relation, not an immediate relation, not an attorney, and not related to the attorneys either, close relation to the attorneys. Very important. Very important name, because if something goes wrong with that power of attorney, or if it's ever challenged, it's a certificate provider who's written to first. Preferences and instructions. I talked about that a few minutes ago. So within the power of attorney, you have 2 boxes, one for preferences, one for instructions. Preferences are your wishes. Typically on the financials one, there's very few in terms of wishes we have, but on the health one, many people write things like, if I'm in a coma, I'm in a vegetative state, I don't want to prolong life on life support machine or on a machine, things like that. Or I prefer to have care at home rather than in a care home. Preferences are not legally binding. All it is they're your wishes. Ultimately, the decisions are your attorneys. but they will look at your preferences. They will look at what mum and dad's wishes are. So it's vitally important. Example, life support machine. You're coming to the end of your life. One child says, nope, I want that machine to be kept on for as long as possible. The other one will say, look, no, mum would have wanted this or dad would have wanted this. If you have it written down, there's no argument. Both the children have got that power of attorney actually there, sitting there. So instructions are things you write which are legally binding. Like I gave the example about the DNR, anything in that instructions box is legally binding. So we don't do that many because you don't want to restrict your attorneys when it physically comes to taking decisions, could be years down the line. Notifying others, this has now become an option. It used to be compulsory on power of attorneys, but people who have very few people they know or relatives, you may want to notify a friend or another relative to say, look, I'm taking out and registering power of attorneys. This is just something for them to be on the back of their mind in case tomorrow something goes disastrously wrong or they see, there's abuse, coercion, whatever. It will trigger them that, look, actually, there was a power of attorney and they can, a legal profession can do further checks. So what happens if you have lost your power of marbles, you have lost your capacity, but you don't have a power of attorney? The only other route is for financial matters is basically a court of protection application or a COP application, or sometimes known as a deputyship order. Really important to have, but you've lost capacity, you don't have a power of attorney, and people who care for you, who want to act in your best interest, will need to put this application in. So it's not derived from you, it's the other way around. It's an expensive process, it's a long process, and generally speaking, they don't grant these on health matters. Typically, it's only on financial matters. It comes with conditions, so the court will need to see an annual set of accounts, so expenses, and how you've spent the money, how the income is coming, because you are a vulnerable person now. If you've lost capacity, you become a vulnerable person. So the court's duty is to look after you. So they want to make sure if there is any kind of abuse, taken advantage of, whatever, they will try and stamp it out as early as possible if they can. So please try to plan early. Do not get into this situation where you need a deputyship order. Plan early and get power of attorneys done, lasting power of attorney done. Not going to go through the stats, but they're there. Costs. So basically, there's a registration fee. If you're on certain government benefits, like guaranteed pension or very low income under 12,000, you can get some kind of exemptions on the registration fee. This registration fee on 15th of November, it's going up to £92. 15th, 17th of November, it's going up to 92. And if you go to a professional, obviously they will charge you in terms of their time and drafting fees. Now, again, a very short video, typically repeating some of the stuff I've said, but in a more animated way. So here goes.
Have you made your lasting power of attorney yet? Nobody wants to think about having an accident or illness, or that as we get older, we might find life more difficult and need support from others. If we ignore the risks and don't take any action, the reality is we create problems for ourselves and our loved ones. A lasting power of attorney is a legal document where you choose people you trust to be your attorneys. It will give you peace of mind, and your attorneys the legal powers they need to be your voice and make decisions on your behalf. It's recommended that you have both types of lasting power of attorney in place for complete protection. What happens if I don't make a lasting power of attorney? If you lose mental capacity and do not have a lasting power of attorney, your loved ones will be stuck and unable to help you. They won't be able to access your bank accounts, manage your property, or have a legal voice in health or social care decisions. If you lose mental capacity, a court order known as deputyship will be needed. This is a more complex, time-consuming, and expensive process compared to making a lasting power of attorney. Here are some common myths that stop people making a lasting power of attorney. You don't need an LPA if you are married or have joint bank accounts. Marriage does not give you legal rights over your spouse or civil partner. Banks can freeze joint accounts to protect the incapacitated bank account holder. I've made a will, so I don't need a lasting power of attorney. A lasting power of attorney applies only when you are alive. Your will applies only on your death. You need both documents to be fully protected. I'm young and healthy. I don't need an LPA yet. None of us know what is around the corner. Head injuries and strokes can take place suddenly and at any age. You need to be able to consent to making an LPA. Don't leave it too late or get caught out by myths. Making a lasting power of attorney is as important as making a will.
Okay, so Rowena, I've come to the end of both the presentations.
Wonderful, Shandip, and thank you so much for all that information. There are a couple of questions that have come through.
Mhm.
So the first one is, who is the best person to act as an independent trustee?
Independent trustee ideally must not be connected to the beneficiaries. So depending on who the beneficiaries are within that trust, independent trustee can be either a close friend, someone who knows the family dynamics a little bit. Trustee role is a long role. It could last for a number of years. I mean, a discretionary trust lasts for 125 years, but a trustee role could last for a number of years.
Mhm.
A professional firm is a second option. There are firms of trustees, firms who specialize in trusteeship work who can be that, and you basically give them a letter of wishes when you've either made your will or if you're doing a lifetime trust with the full instructions or wishes and guidance to them. So they will absolutely stick by that, but it's a cost. Could be quite a cost for professional trusteeship. Most common tends to be very close friends or relatives who are not connected to the beneficiary.
Great. Yeah,
Directly.
thank you. That clarifies that. And I have a question regarding to this letter of wishes, actually. What is the difference between a letter of wishes and a will?
Letter of wishes is not legally binding, the will is.
Okay.
The letter of wishes, as the word says, is your wishes. So when a will goes into probate, the will becomes public property, the letter of wishes doesn't. The letter of wishes is there just for the executor and the trustees to say, my wish is, this is how I want my estate or my trust. But if there's no trust, this is my wishes. So in the wishes, you can have things like some people have funeral wishes, personal chattels wishes. So, I want my ring or earrings or whatever to go here to my granddaughter. I want this to go to my grandson, etc., all of that. Legal letter of wishes is not legally binding.
Right. Okay.
It is simply a list of wishes.
Yeah. Okay. And are there any further fees after a trust is set up?
So if the trust is set up either while you're alive or after you've died, yes, there are. So first, the trust has to be registered with the HMRC. Then you have to submit an annual set of accounts. Trustees, especially Upper Asians, Gujaratis, Jains are pretty good financially. So doing trust accounts should not be expensive. But our trust, or the company we use, I'll give you an example. They do trust accounts on an annual basis. They charge around £500 to £600. Very straightforward. What's gone in, what's come out, etc. Trust then has 10 yearly charges, 10 yearly trust taxation. Okay, so the trust is revalued every 10 years. You then have your standard inheritance tax allowance, which could be 650,000 or whatever it is at the date. Anything above that, the trust is grown, anything above that will get charged at the trust taxation rate, which currently is 6%. Okay, so trust has its own 10 yearly charges. Then there's exit charges, etc. if you withdraw or whatever. That gets a bit complicated. I don't deal with that side, but there are certain charges, yes.
Okay, that's very clear then. Just a couple more questions then before we wrap up. Is then, in your experience, how do people choose their trustee? What is there a criteria? Or is it just that, oh yes, I like you, so I trust you, and that's that?
The word trustee gives away the answer. You have to have trust in that person.
Right.
Okay. That's where the name derives from.
Mm,
You have to have trust in that person to be able to make those decisions of your estate. You won't be here to police it.
sure.
So you have to rely on them.
Yeah.
Trustee is also guided by the Trustees Act and governed by the Trustees Act. So if they do anything wrong, they are personally liable for the trust.
Right.
Or if something goes wrong within that trust, they are personally liable and they could face criminal charges. It's very important. The person you choose as a trustee, you have to have utmost faith that they will do the right thing. Ultimately, it's a discretionary trustee, you're leaving it at the discretion of the trustees.
Right.
With a letter of wishes, giving them guidance, etc. That's the best you can do. You can't do anything.
Mm. And what are the pitfalls to avoid in all of this?
So you're talking about wills, power of attorneys,
Yeah. Yeah.
both.
Yeah.
Pitfalls. So one of the things I mentioned in the wills is excluding or
Mm,
giving one beneficiary a lot less than the other without explanation.
yeah.
Big pitfall, because that can end up in a court case afterwards, the will being contested. If there's a husband and wife, children, everything is hunky-dory in terms of relationships, but one spouse decides in their will they want to give everything to their children. That's, and if you've not thought about it, first, that could be a huge tax bill. Second, is there enough for the surviving spouse to live on just because you don't, you wanted to go somewhere else directly to children or whatever? I shouldn't say this, but one of the things which people don't appreciate is how much work goes into it from a professional in drafting these documents. All professionals have to have professional indemnity insurance. If something goes wrong, I carry a cover of 2.5 million. Something goes wrong, there is a cover there. People doing wills on the cheap, you can get £20 wills online, go to WH Smith, you can pick up. When is a mistake going to come to light? If you haven't changed it, it's going to come to light after you've died. Or if you've done something wrong, or if you've written something wrong, it's coming to light after you're died. That could be the most costly mistake in your estate.
Yeah. Yeah. That sounds like a very, very good
And of
advice.
course, another not pitfall is not having the documents at all.
Yeah.
I get that all the time. The other side where I haven't got a lasting power of attorney, mum's lost capacity. Please, can you just come and do it for us as a favor? Sorry, doesn't work.
Mm. Yeah. 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 And does inheritance affect any benefits that people might receive?
So, in which way, where are you coming from as a stance on
So
this?
if you have a child who's receiving benefits,
Got it.
and if a grandfather leaves them some money, does it affect their benefits? I don't know if this is actually related to
So
this.
it doesn't affect the benefits, but so there's two ways of giving. If you've given them via a trust, vulnerable person's trust or discretionary trust, it doesn't belong to the beneficiary. So no, it's not going to affect their benefits.
Yeah.
If you've given them a direct gift, say I give my grandson £10,000, but they're disabled or whatever, that will increase the value of their assets. And whatever the figures are now, if it's over 23,250, it could impact on their benefits. Absolutely.
Yeah. Okay. I think this might be the final question. What can you do to reduce inheritance tax from parents to children?
Now, that's a topic on its own. Okay.
Okay.
We do presentations on inheritance tax advisors. There are so many things, but the simple things, we've got a couple of minutes. The simple things from parents to children, lifetime planning. So start to, if you can afford to, give away while you're alive, as much as you can, subject to 7 years survival.
Yeah.
Gifting is the big one. If you're young, maybe you take out life cover to protect and to pay for your inheritance tax. Um, you've there's gifting, but the other side is make sure you don't gift everything away. Don't let the tax tail make your decisions simply because if you, in your latter part of your life, when you need money for healthcare, etc., and you don't have anything, don't expect your child to give you that money.
Yes.
આપણાથી હાથ લાંબા નથી થતા એકવાર આપી દીધું પછી. So it's really important to hear that. A great way of doing saving inheritance tax, spend your money.
Love that.
Yeah. So one of the lines I have is, business class flights are 40% cheaper at the moment. Right? So biggest, and again, it is a bit of humor, but the biggest issues we have within our communities is we have always been brought up and used to saving.
Yes.
Even as you go later in life, your kids are doing absolutely fine. They want you to spend the money, yet you won't spend the money when you go on holidays or when you want the house done or whatever. It's the psyche we are.
Yeah.
I can guarantee you your children won't thank you for this. They won't say, oh, thank you, you've left me a bit more money. They're already doing well. They don't need that because you're making their inheritance tax situation worse.
Yeah.
But spend the money because, or not spend everything, but, be a bit more generous. Give to charity. That's, again, saving a lot of tax as well. You're giving to a right cause rather than the government. And yeah, there are lots of ways, trusts, there's offshore, there's changing of residency. Everything depends on the value of your estate, what your objectives are, your financial situation, your kids' financial situations, all of that. There's a saying in our industry, the first generation saves, second generation builds on that, third generation blows it. So, and it is pretty much true in most big wealthy families.
Oh God, I wish I was the third generation. What we have now is actually some really good feedback, if I might share that, Shandip.
Oh.
Is that it's been a fantastic webinar. It's been thank you for setting it up. May have been better to split it into two separate webinars, one for wills, trusts, and second for LPAs to allow for questions, something as an enabling network we can take on board. And yeah, another person said they think they need another one because there are so many questions. Feedback again, brilliant, very well explained. Thank you for explaining that. And oh, I do have another question actually. Can a trustee be from abroad?
Yes, they can. They can be from abroad, especially with the technology we have these days. Practically, sometimes they could be facing challenges, but look, the globe is becoming a lot smaller and they can travel in or whatever. But yes, they can be abroad. Attorneys can be abroad, executors can be abroad, beneficiaries can be abroad.
That's fantastic. We will wrap up now, Shandip, if that's okay. And if anyone has any further questions for Shandip, just send them to us at en@oshwal.org, and we'll hope some of these questions can be answered by Shandip. Thank you, Shandip, for a very informative and all the useful nuggets to help the families navigate the world of wills, trusts, and power of attorney. Now, if you've
Thank you to Enabling Network for putting this on. A really important topic, but I hope people take whatever I've given on board, make their own decisions, go to their professional providers. But thank you for Enabling Network on a Sunday night to still be working and doing your voluntary work. That's fantastic. So thank you.
Thank you to you too as well. And for anyone else, if you've missed any of the other webinars, you can catch up on Oshwal's YouTube channel under Living Beyond Barriers. And just to point out, Enabling Network celebrates International Day of Persons with Disability annually. This year, we're marking it by hosting a music and magical event on the 29th of November. All the information and ticket details are on the Oshwal website, and it is open to everybody, and hope to see you there. And lastly, very much thanks to the IT team for their constant support. There's a lot that goes on in the background with these webinars, and for all of you for joining us. So bye for now.
अरिहंत प्रभु ना दर्शन करता सर्व साधुने वंदन करता सम्यक दर्शन मुझने मळजो सम्यक ज्ञान मुझने